Does a worker's permit from Services New South Wales mean that you are approved as an authorised worker to enable you or your employees to work outside of an LGA of concern? If your business is not included in the authorised workers list, but your client that you're going to service is, does this mean that your worker is considered an authorised worker? This question is one that we recently had from a client, and we wanted to share our logic in providing advice with the disclaimer that this was our interpretation of the current New South Wales health orders, and others, including law enforcement, may form their own view. The scenario was that the client had employees that lived in an LGA of concern and was contracted to do some work outside their LGA to conduct cleaning and ground maintenance work for manufacturing businesses in a different impacted LGA that was allowed to be open. Now, the first challenge is that cleaning and grounds maintenance is not listed in the list of authorised workers provided by the New South Wales government. However, our view was that as the manufacturing business was authorised to be open, and our clients' services were essential to the operations of the manufacturing businesses, they would be in fact considered authorised workers and be permitted to work, providing they met with other requirements, including vaccinations and a valid work permit from Services New South Wales. Now, the second question was, if our client was required to provide documentation explaining this in the event that their employees were questioned by law enforcement or other authorities. We formed the view that this would not be the case, as they would be in possession of a work permit. However, the interesting conversation that we had behind the scenes is if the employees could be penalised for not being an authorised worker if they were in fact in possession of a work permit. The interesting outcome from this internal conversation was that there was apparently no approval process for the work permit. And when asking those that had already applied for the permit, they had received this permit within minutes of application. So based on this, with the lack of oversight on the application process, we feel that simply the possession of a permit is not sufficient to prove that a worker is in fact an authorised worker. Now, we don't have all the answers with this one. Like many scenarios with the current New South Wales health orders, there are no black or white answers, and businesses must use their common sense and make decisions based on the spirit and intention of the current lockdown restrictions. We would welcome any feedback or differing views on this in the comments, and hoping that you're all staying positive.